A pleasant day to each and everyone, especially to your mom. This is Marimar Oclida, and I'm going to report on the chapter 12 of the subject Legal Aspects in Tourism and Hospitality. It is entitled Laws Related to Tourism Investments and Finance. So, these are our learning objectives. First is to enumerate the procedure in setting up a tourism-oriented business. Second is to explain laws governing tourism investments and financing tourism-oriented projects. Third is to discuss the business models applicable to tourism projects. And last is to enumerate the various taxes application to tourism-related establishments. So this chapter deals with the laws related to promotion, monitoring, and regulation of tourism investments and finance in the country. Basically, this will tackle the participation of foreign investors as well as the incentives given to Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector, which is the Filipino balikbayans, retirees, and senior citizens. So the first law is the Foreign Investments Act of 1991. So the Republic Act 7042 as amended by Republic Act 8179 on March 25, 1996, also known as the Foreign Investment Act of 1991, provides for the policy that foreigners can now invest in all activities and enterprises in the Philippines except those covered in the negative list. So, when a foreign investment in the Philippines is not covered or does not seek incentives under the Omnibus Investment Code, the foreign national or entity can ascertain the extent of allowable foreign equity in the enterprise sought to be entered into by simply referring to the negative list and filing the necessary requirements with the Securities and Exchange Commission. And when we say foreign investment, it refers to the investment made by individuals, companies, or governments from one country in assets or projects located in another country. So, these investments can take various forms, such as purchasing stocks or bonds of foreign companies, establishing new businesses or subsidiaries abroad, acquiring real estate, or investing in infrastructure projects. So, under the Foreign Investment Act of 1981, a foreign national or equity must determine the kind of enterprise sought to be entered into, whether the enterprise is a domestic market enterprise or an export enterprise. So, when we say a domestic market enterprise, it refers to a business that primarily operates within the borders of a single country, focusing on serving the local market and customers within that country. While the export enterprise, it refers to a business that primarily focuses on selling goods or service to customers located in foreign countries. So, unlike domestic market enterprise that target local consumers, um, export enterprises engage in international trade and operate with the goal of expanding their markets reach beyond their home country's borders. So next is the investment in transportation business and public utilities. So the law stated that for common carriers such as the airline, land, and water transportation business, the operator of such involve public service which shall be granted to um, which shall be granted only to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines or at least 60% percentum of whose capital is owned by such citizens, or in other words, foreign participations is limited to only 40%. Moving forward, we have the investment in hotels, resorts, and other accommodation establishments. So, the enactment of Memorandum Order Number 211 approving the 2006 Investment Priorities Plan on April 4, 2006 tourism has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. So tourism covers the development of tourism economic zones, tourist estates, eco-agritourism facilities, and the establishment of tourism accommodation facilities like the hotels, resorts, and other tourism accommodations, and facilities such as apartheid, pension houses, tourist inns, and similar establishments. Then we have also the application of the retail trade law for restaurants and shops. So the law stated that restaurants and other tourism-related establishments, such as department stores and shops, are governed by the laws on retail trade by reason of the nature of their business. So in the past, operations and ownership of these establishments are confined only to Filipino citizens or to corporations and associations fully owned by Filipino citizens. So by reason of the enactment of the Retail Trade Liberalization Act of 2000, foreign investors may now engage in the retail trade subject to capital requirements. So the following sales transactions are exempted under the coverage of the Retail Trade Liberalization Act of 2000 and are therefore allowed 100% foreign ownership participation. So, by a manufacturer, process, laborer, or worker to the general public, the products manufactured, processed, produced by him if his capital does not exceed 100,000 pesos. Next, by manufacturer of his product in a single outlet, irrespective of capitalization. And last is in restaurants incidental to the hotel business. Moving forward, we have also here the tourism projects under the Build, Operate, and Transfer program or the BOT program. Republic Act Number 6987 as amended by Republic Act 7718, referred to as the BOT Law, implements the declared policy of the state to recognize the indispensable role of the private sector as the main engine for the national growth and development and provide the most appropriate favorable incentive to mobilize the private resources for the purpose. The following are the schemes recognized under the law. We have the build and transfer, the BT. The project proponent finances and constructs an infrastructure, then transfers it to the agency or the LGU after completion, receiving payments for the investment plus a return. Next, we have the build, lease, and transfer, the BLT. The project proponent finance and constructs an infrastructure, leases it to the agency or LGU for a fixed period, and then transfers of ownership after the lease period. Next, the build, own, and operate, the BOO. The project proponent finances, constructs, owns, operates, and maintain an infrastructure, recovering costs and earning returns through tolls or charges. Fourth is the build, operate, and transfer, the BOT. This project proponent finances, constructs, operates, and maintains all infrastructure, recovering costs through user charges, then transfers it to the agency or LGU after an agreement or after an agreed term. Next is the build, transfer, and operate, the BTO. It is the agency or LGU contracts a private entity to construct an infrastructure, which is transferred to the agency or LGU after completion, while the private entity operates it. Next, number 6 is the contract, add, and operate, CAO. The project proponent adds to an existing infrastructure facility rented from the government and operates the expanded projects for an agreed period. Seventh is the develop, operates, and transfer, DOT. The project proponent develops an infrastructure project with favorable conditions, integrating adjoining property, development rights, and enjoys related benefits. Next, to be followed by the rehabilitate, operate, and transfer, ROT, an existing facility is refurbished and operated indefinitely by the project proponent as long as they comply with the franchise terms. And last is um, last is the rehabilitation own and operate or the ROO. It is an existing facility which is refurbished and operated indefinitely by the project proponent as long as they comply with the franchise terms. So when we say build, operate, and transfer, or BOT, it is a contractual arrangements where a private entity, which is the project proponent, builds and operates infrastructure projects, recouping cost through user fees, and then transfers ownership to the government or relevant authority after a specified period. Next is the investment in Next is the investment incentives and government undertakings under the BOT law, subject to existing laws, policies, rules, and regulations. The government may provide any form of direct or indirect support or contribution, such as but not limited to the following. First is the cost sharing. So the agency or LGU may be a portion of capital expenses not exceeding 50% of the project cost with the balance provided by the project proponent. Second is the credit enhancement. This includes direct and indirect support such as government guarantees or assistance in maintaining financial standing to avoid fault or project loans. Third is the direct government subsidy. The government defrays project costs, contributes assets, waives fees, or provide other forms of support without receiving payment from the project proponent. Fourth is the direct government equity. The government subscribes to share of stocks or securities convertible to shares in the project company. Next is the performance undertaking. Um, the government entities assumed responsibility for fulfilling contractual obligations, including payment in case of default. And next is the legal assistance. This shall refer to the extension of representation by government lawyers to a proponent, but only in cases, hearings, or inquiries where the agency or LGU and project proponent are party defendants or respondents therein, including the adoption by such government lawyers of positions and strategies consistent with upholding the validity of the approved contractual arrangement. And legal assistance is providing legal representation in relevant cases to uphold the contract's validity. And last is the security assistance. This shall refer to the deployment of government security forces, either from the Philippine National Police or the Armed Forces of the Philippines, in the vicinity of the project site to provide security during the implementation of the project up to completion. So security assistance is deploying security forces for project site security during implementation. Then we have the applicable negotiable instruments and documents of the title. So the law stated that by way of introduction, the laws applicable for purposes of discussion of the different negotiable instruments and documents of the title in tourism investments are as follows. First is the Act 2031, also known as the Negotiable Instrument Law. Second is the Presidential Decree number 1115. Presidential Decree number 115, providing for the regulation of trust receipts transactions. And third is the Warehouse Receipts Law Act of 2137. So here are other commercial documents. So the following commercial documents are also useful in merchandising, importation, and exportation of goods, which may also be utilized in the tourism industry. First is the invoice. It is a details goods shipped or sold, including prices and charges. Second is the sales invoice. It is a records agreement details from sales negotiations. And third is the purchase order. It is a contract for ordered goods sent to the supplier, becoming a binding contract upon acceptance. Fourth is the bill of lading. Um, the carrier issued documents specifying delivery terms, serving as both receipt and transport contract. Fifth is the warehouse receipt. It encourages transactions on negotiable warehouse receipts, transferring title over the covered commodity. Next is the trust receipt. It is where the bank released goods to the entrustee while retaining ownership until full payment of liabilities. And last is the letter of credit, the bank to bank instruments authorizing drafts on behalf of customers under credit conditions, aiding in um, aiding in safe sales transactions. So these documents facilitate various aspects of commercial transactions, from ordering goods to ensuring payments and ownership rights. So moving on, we have the Special Economic Zone Act of 1995, also known as the Republic Act 7916. The Special Economic Zone Act of 1995 establishes the legal framework for creating and managing special economic zones in the Philippines, administered by the Philippine Economic Zone Authority, or the PEZA. This law allows tourism and development zones and estates to obtain SEZ, or the Special Economic Zone status upon registration with PEZA, with incentives including up to 100% foreign ownership, income tax holidays, special tax rates, duty-free importation of capital equipment, special investor visas, employment of foreign nationals, and other incentives determined by the PEZA board. And lastly is the Barangay Micro Business Enterprise Law. So the Barangay Micro Business Enterprise Law Act of 2002 aims to stimulate economic development by supporting small businesses, integrating informal sector enterprises into the formal economy, and generating employment. BMBES are defined as business with total assets not exceeding to 3 million pesos, and the registration involves applying at the municipal or city treasurer's office and obtaining of certificate of authority, valid for 2 years and renewable for 1 to 2 years. So the BMBS, or the Barangay Micro Business Enterprise, enjoy income tax exemption and may receive reduction or exemption from local taxes, fees, and charges. They are also exempt from the minimum wage law but must provide social security and healthcare benefits to their employees. So that's all for the chapter 12. I hope you have learned something. Thank you for listening.